Good evening, everyone, and welcome to Marquette University Law School for tonight's Supreme Court Candidates Debate. I'm Mike Gousha. I'm a distinguished fellow in law and public policy here at the law school. I'll be your moderator tonight and also one of the people asking questions. Just a couple of minutes, we'll meet the other two individuals who will be joining me on the panel tonight of questioners. Before we meet them, though, let's meet the candidates. Joining us tonight are Linda Clifford, the Madison attorney, and Annette Ziegler, Washington County Circuit Court judge. Thanks to both of you for being with us tonight. Do appreciate it. Joining me on the panel, the people who will be asking the questions of the candidates tonight are Greg Borowski. He is a political reporter for the Milwaukee Journal Sentinel, and Dan Blinka. He is a professor here at Marquette Law School. A couple of quick notes about tonight's debate. It is being sponsored by Marquette Law School, the Journal Sentinel, and Time Warner Cable. You can see a rebroadcast of this event on Time Warner Cable's Channel 1111. That's Wisconsin On Demand. That will begin airing, I believe, in about 24 hours from now. Also want to mention that each candidate will have a 2-minute opening statement in this 1-hour debate. They will each have 1 minute for a closing statement. In between there, we're going to be asking questions of the candidates. Now, we have decided that there will not be time restrictions on their answers. We have done that, frankly, because some questions deserve more time in terms of an answer, and some questions probably deserve less. And so we will not have time restrictions, but having said that, we will ask the candidates to be clear, concise, and direct in their responses. We will also allow the panelists to ask a follow-up question if need be. And if we get bogged down and we seem to be covering the same old ground over and over and over again, we will move on because we have a lot of ground we want to cover tonight. Let's begin with tonight's opening statements. And we have done the old coin flip and made the determination that Linda Clifford will go first tonight. Linda Clifford.
Thanks so much, Mike. And thanks to the sponsors for organizing this event. It's good to be here. Between now and April 3rd, in choosing between me and Annette Ziegler, I urge you to study and scrutinize our personal background and our professional record. My background was humble. My dad was a factory worker, my mother a housewife, a homemaker. And together, the two of them taught me the lessons that most inspire me to become a Supreme Court justice, the lessons that I think I'll take with me to the Supreme Court, the value of hard work, the importance of integrity, and the need for fairness for everyone. Those are the values I'll take to the Supreme Court, along with 32 years of quality experience and leadership in the profession of law, both as an assistant attorney general and as a lawyer in private practice. I understand the job of a Supreme Court justice because in my 32 years as a practitioner, I've handled more than 30 appellate cases in state and federal courts. I'm the only candidate who has argued in front of the Wisconsin Supreme Court. I believe that the cornerstone of our judicial system is public confidence in the integrity of the attorneys and judges who serve it. And that's why for 9 years I served the Supreme Court's committee to study and investigate attorney misconduct and recommend discipline. And that's why I am so troubled by the newspaper accounts of my opponent's failure to comply with ethical restrictions involving conflicts of interest. She denies it's a scandal. I think it is scandalous that a sitting judge would have such a flagrant disregard for the code of ethics. And she's not been able to answer the question, did you just not know about the rule, or did you decide to disregard it? When you compare my record with my opponent's, I think the choice is clear, and I would welcome and be honored by your vote on April 3rd.
Annette Ziegler, a 2-minute opening statement, please.
All right. Thank you, Mike. Thank you to the Milwaukee Journal Sentinel, and thank you to my alma mater, Marquette. It's nice to be back here in familiar territory. I am running for the Supreme Court seat that's being vacated by Justice Wilcox. April 3rd, you'll have a choice as to who you want to select to sit on the highest court in the state. Of the two of us here, I'm the only person who has sat as a trial court judge. I've presided in a court of general jurisdiction, which means we hear everything: civil, criminal, family, juvenile, probate, adoptions, mental commitment hearings, a variety of hearings across the board, and a lot of them. Over 25,000 cases I have heard over the last 10 years. Prior to that, I was a prosecutor, and I worked here in Milwaukee County, helping keep the neighborhoods safe and the streets safe, and I enjoyed that position very much, both as a state prosecutor and as a federal criminal prosecutor. You see, I've devoted my life to serving the public, and I'm proud of that fact. I also am proud of the fact that I was in private practice, and I understand what it is like to bill every 6 minutes and have the constraints that exist in private practice, but that's yet one area of the law. The issues that the Supreme Court sees are wide in variety: civil, criminal, family, termination of parental rights, across the board. And there's only one candidate who has dealt with all of those issues. I'm proud of the support that I've received in this campaign. I'm proud of the fact that every law enforcement agency that's endorsed has endorsed me. The majority of district attorneys and sheriffs around the state, Republicans and Democrats, and a long list of both, have endorsed my candidacy. My fellow trial court judges, the majority of them in the state, who understand what it's like to be a trial court judge, have endorsed my candidacy. Past Supreme Court Justices Cece, Steinmetz, and Callow have all endorsed my candidacy. And that speaks volumes. I think it's important that you consider our background and our experience when making the choice, and I ask for your support and vote.
Thank you very much. We'll now begin the question and answer portion of tonight's debate. The first question will come from Greg Borowski with the Milwaukee Journal Sentinel. Greg?
Good evening, everyone. I'm going to start with Judge Ziegler. The election is just over 2 weeks away on April 3rd. It's obviously a very important election. It could help shape the direction of the Supreme Court for years to come. I want to ask you both about the man that you want to replace on the bench, Justice John Wilcox. For the benefit of those here, could you please compare yourself to Justice Wilcox in terms of your philosophy, your demeanor, and your approach to the law?
Well, I would not have run against Justice Wilcox, so let's start there. Unlike Attorney Clifford, who was running against him, I wouldn't have. When he decided to retire, that's when I decided that the voters deserved an opportunity and a choice. Justice Wilcox comes from a smaller community, much like Washington County. Diversity comes in a lot of ways on our Supreme Court, but the issues that exist in a smaller county are very different than Milwaukee or other counties, and I happen to have the luxury of having worked and lived in Milwaukee, but also work and live in a smaller community. That's an important perspective to remember. Also, Justice Wilcox had trial court judge experience. Now, that's a seat that's going to be missing on the Supreme Court when he leaves. I think that I could help fill that seat with someone who's been practicing for the last 10 years, and the laws have changed a lot in the last 10 years. We have 980 commitments that didn't exist 10 years ago. Truth in sentencing didn't exist 10 years ago. Guardianship law has had wholesale change. We have change in the family law procedures, change in TPRs, changes in the economic loss doctrine, changes in theories of liability. A lot of changes that we trial court judges have to deal with on a regular daily basis. And so I think I'm well suited to fill that seat because we have very similar characteristics as far as where we come from and our background and experience.
Okay, thank you. Linda Clifford, same question.
Okay. I don't consider myself about to replace Judge Wilcox, but rather running for an open seat that starts from ground zero. I had considered running against Justice Wilcox, actually, but he spared me the obligation to make that tough choice when he decided to retire. Actually, I have worked with Justice Wilcox on committees at the State Bar. When I chaired the Media Law Relations Committee of the State Bar, John Wilcox was a member of that committee, and he served on the committee long and well, offering his expertise in some of the issues that our committee faced, dealing with educating news personnel about the legal committee, the legal community, and educating the legal community about news reporters' obligations. It's true that Justice Wilcox had been a trial judge before he took the seat on the Supreme Court, but as I said, I'm not seeking to replace his qualifications or his expertise, because what I'm running to do is to restore professional balance on the court. Just 10 years ago, most of the justices on the court came from outside the court system with no prior judicial experience, and that has shifted now so that there are 4 prior trial judges on the court, which I think destroys the balance of professional diversity that the court deserves. Most recently, our Supreme Court Chief Justice came to the court without prior judicial experience, and the 2 prior Chief Justices before her, Rolly Day and Nate Heffernan, came to the court with no prior judicial experience. And that includes, and both of them, of course, are endorsing my candidacy because they understand the importance of diversity of professional experience. We sometimes have legislators on the court, Justice Bablich, Justice Prosser, bring that perspective to the court. So in 2007, the court would benefit more from the addition of a seasoned practitioner than from another trial judge, which are already represented in substantial numbers on the court.
Next question comes from Professor Dan Blinka.
Good evening. You're both very accomplished people, yet forums like this sometimes make it difficult for candidates to convey core values, essential experiences, really a sense of whom you are. What I'd like each of you to do is to describe the hardest decision that you made as a lawyer or as a judge. In particular, tell us why that experience stands out among so many others in your careers. Why should it be important to us? How did you resolve it? Linda Clifford?
I think lawyers constantly face the difficult decision of advising clients who believe in principle that they need to litigate, that they should not, for a number of different reasons. And I think sometimes when I know my client is right and deserves to win, sometimes the hardest decision is advising, serving as an advisor and counselor to recommend that the client not proceed because of various risks that include costs, that includes the possibility of losing, that includes sometimes the destruction of families, and that prevents the client from getting on with his or her life. And I think I won't describe a particular case specifically, but that's the nature of some of the most difficult decisions that I make as an attorney.
Without breaching any confidences, does one particular incident or problem stand out in your mind over your long career?
Because it's so long, I really would have a hard time identifying any one that was particular. If it comes to me, I'll certainly raise it before we leave this question.
Thank you. Judge Ziegler?
I would say, having dealt with, and again, over 25,000 cases, it is hard to select just one. More recently, I can think of cases where I've had to deal with serious sexual assaults of a stepdaughter and watched her go through the difficult motion practice, the preliminary hearing, the trial, and be questioned, cross-examined, have to look into the eyes of the person that she was accusing, feeling like she didn't have support there. Ultimately, the person was convicted, and through sentencing, I was able to at least tell her, I hear you, I understand you, and the person will never be bothering her again because that person will be incarcerated for probably the remainder of his life. Those are difficult situations, and those are the kinds of situations we judges see on a daily basis. Different setting, termination of parental rights. I had a case with a mother who had a very significant, serious alcohol issue. 0.626 was her alcohol level. Most people would be dead, should be dead. And she had several children. Her children needed to be taken away from her. That is a difficult thing to do to anyone. And ultimately, a couple years later, and it was within the last year or year and a half, she was able to regain her children. I mean, this is a success story. It was difficult at the time, but it shows that she was able to devote her attention to the things she needed to devote it to and get the treatment and get the counseling and pull it together. And now that family is far more cohesive and better off as a result. You know, I could go down the line, family court cases, guardianships, mental commitment hearings on alcohol commitments, or when someone has a significant eating disorder and parents are deeply troubled by the fact that their child's about to die because they're not eating. You know, there are very significant decisions on a daily basis made by trial court judges, and they strike at your core values.
Thank you.
Next question for both of you, and you both have said this. I've heard you at forums say this and seen you on television saying this, that this race is nonpartisan. And yet, in fact, many outside partisan groups have made their involvement in this race very clear. They have inserted themselves pretty aggressively at times into the debate. Of the statements made that support you or criticize your opponent, are there any you disagree with and would choose to distance yourself from? Or can voters assume that by silence you agree with the tone and the tactics? And we'll start with Annette Ziegler on this one.
I'm glad you asked that question because partisan politics don't belong in a judicial race, which is precisely why I asked my opponent to sign a clean and honest campaign pledge, and she declined that invitation. I think we're seeing why. For the first time in a judicial race, we have someone who's hired a private investigator to investigate me and my family. That's unprecedented. For the first time in a judicial race, we see someone come out with their first ad be an attack ad. That's unprecedented in a judicial race. Partisan politics don't belong in a judicial race, no matter how much you might want to win the seat. Now, I'm proud of the fact that I have support from Republicans and Democrats across the board in a long list, not just one, a long list of each. I'm proud of the support that I have, the DAs in the state, sheriffs in the state, law enforcement organizations, other judges, other nonpartisan people. I've lived a nonpartisan life for the last 10 years. I've never particularly been involved in politics much anyway. But with respect to my job as a judge, it is to check any ideology at the door and decide a case based upon the facts and the law as they're presented, not a political prism.
Linda Clifford.
I find this series of statements interesting, that a judge would object to a review of her public record by the news press and by the media is troubling to me, because a judge who runs on her record needs to invite scrutiny of her public record. So the employment of a researcher to review that record is entirely appropriate, as is an advertisement that is comparative between my record and my opponent's record, which only acknowledges a series of editorials from 7 newspapers across the state which have challenged her ethical violations. And certainly the invitation to sign a clean campaign pledge had to be rejected. I have signed an honest campaign pledge, and I'm committing myself to an honest campaign between me and the voters of Wisconsin. I don't need to negotiate a campaign pledge with my opponent, who has already initiated attacks against the Supreme Court itself, a significant portion of the trial bar, and myself. So to suggest that a campaign ad that compares her record and reflects and initiates discussion of her public record in the public domain as a negative ad is quite disingenuous.
Let me ask you each very briefly to follow up on this. You used the term scandal. Most of the newspaper stories I saw said raise questions, so are you premature to use the word scandal? You're running an ad now that calls her a mudslinging politician. I guess the question is that the appropriate tone for the race for the highest seat in the state, judicial seat? And I'll have you respond in your response.
I think the word scandal is appropriate when newspapers around the state are calling the conduct shameless and shocking, and when over and over again I have asked Judge Ziegler to explain her conduct and never received a satisfactory answer to this violation of the Code of Judicial Conduct. So the word scandal is certainly appropriate. To then apparently hire a bunch of high school kids to go out in the woods and shoot an ad, which turns out to be quite amateurish, and call that mudslinging, as I said before, reflecting the public record, which has already been debated in newspapers, is not mudslinging. That's a fair public debate of the facts.
Let me have a response from you, please.
I welcome an objective review of my cases, and I have no problem with that. Unlike Attorney Clifford, I have a lot of cases that one could review, and people have been reviewing them for months. I've been subject to unprecedented open records requests, which is fine, because that's what I am, a public servant. But don't paint with a broad brush an entire judicial career or over something that default judgments, small claim judgments, things that any judge in the state would rule the exact same way. And even Attorney Clifford knows there's no possibility that there was any bias. There's no possibility in these cases that there was anything that was decided other than based on the law, and there's no possibility of any financial gain in any of these cases. So let's start with the basics here. There is no scandal. And to say that there's a scandal is incorrect, and it's a misrepresentation of my record, and it's a misrepresentation of my career that I have developed as a fair, impartial, ethical, hardworking, well-respected judge.
Can I follow up on that?
Very briefly.
She's using the wrong standard. Whether or not she stood to gain from any of these decisions is not the relevant question. The rules are clear. She had an economic interest based on her husband's seat on the board. She held investments in companies that she heard cases on. That required recusal. There was no discretion on her behalf. Whether or not she had an opportunity to gain is not the issue. The rule makes it a requirement that she recuse or disclose, and she failed to follow the rule, which is a very dangerous pattern of behavior in someone who seeks the highest court or the highest seat in our court. If she can't even read the rules, how can we expect her to reliably interpret statutes?
In fairness, out of time, 20 seconds, please.
Okay,
and we'll move on.
thank you. What I would like Attorney Clifford to discuss is how, if she thinks our husband's positions are so important, how could she possibly sit on the state's highest court and reach conclusions that will directly affect their household income? She'll be deciding whether or not medical malpractice caps stand. She'll be deciding theories of liability. She'll be deciding exactly what kinds of claims her trial lawyer husband can bring and in what context.
Let me have Greg Borowski continue.
We'll return to some of those issues in a bit.
I'd like to
but
address
first-
that, if you
well,
promise to come back to that issue, okay?
Yeah, there are a lot of other issues out there too, and you two are engaged in what will be the most expensive judicial contest in state history. You both dipped into your own pockets to help pay for the race. Outside groups are spending hundreds of thousands of dollars more to influence the outcome. There have been various proposals out there that have called for spending caps, smaller contribution limits, or stronger public financing of judicial campaigns. I want to ask this question to both of you, and I'd ask you to answer it as a candidate and a citizen, not as a potential justice, but what changes, if any, would you make to this election system that you've become so familiar with?
I would like to see changes in campaign finance of especially judicial races. It's going to be too late for this race, unfortunately, but I believe that it's appropriate for this state to look at it. I'm aware that the Brennan Center for Social Justice has commented upon the inadequacy of Wisconsin's campaign finance law and criticizes the campaign limits and other aspects because they're antiquated. It's been more than 20, 30 years since the amounts were set. So it needs to be explored, but it needs to be realistic about the expenditures that are allowed, because this is a very big state, and it's very expensive to get a message to all voters about the qualifications and stature of the parties who are running for this office. Also, I'm concerned that incumbents may have an advantage because of their built-in name recognition, which, if caps or limitations were set equally, would disadvantage any challenger. So those are a couple of the considerations that I would like to see go into any proposal.
Okay. Judge Ziegler.
I would agree with you wholeheartedly. I think campaigns have become way too expensive, and this one indeed falls within that thread. With respect to campaign finance or campaign reform, judicial races might be a good place to take a look and start. But I can't think of a magic bullet on how you fix this particular problem. First off, it's incredibly expensive to run a race, period, especially if you're going to be on TV. That's really what ends up driving the race and the cost of the race. So in order to have any sort of finance, you're going to have it at a meaningful sum so that someone can get their message out. That's the practical concern of it. Second, if you don't allow candidates to get their own message out, you really do relinquish a race to special interest groups who then completely take over, and really your message is lost in the course. So I hope we can find a better way to do that. I think a start would have potentially been the Clean and Honest Campaign Pledge here, because then we wouldn't be dealing with some of the negative attacks that we're seeing. But that would be a starting point.
Daniel Blinka.
I'd like to continue with the theme of judicial elections. You both have a lot of friends throughout the state and certainly in this room tonight. In the 1920s, one of our many not-so-great presidents, Warren Harding, was asked if he feared his political enemies, and he said, and I'll paraphrase, "I have no trouble with my enemies, but my friends, my gosh darn friends, they're the ones that keep me awake at night." In this election, as I said, both of you have a lot of friends. Starting with Judge Ziegler, tell us about which of your friends, your groups or persons, individuals who support you that you believe are most significant or should be most significant to voters, and which of your opponent's supporters should be closely watched by voters. Judge Ziegler?
Oh, that's a good question. Well, you know, we're hearkening back to what I was just talking about to a large degree. There are groups that want each of us to win. Those are the people that scare me the most, because you have no control over their message. You can't communicate with them in any respect. You don't know what they're going to do, and they have resources. So they can get a message out there that you may not want yourself at all, and then it becomes a message that's attributed to your campaign. Similarly, Attorney Clifford has supporters out there that may do the same thing, which is frankly why, as part of my campaign pledge, I said if we could engage in this, at least the two of us could be on the same page. And if there's a third party that goes out there and does something negative, whether it's for or against me, denounce it. Say we want no part of that. We don't want this in this campaign. And that, to me, was a reasonable starting point, at least, to make sure that we sort of equalize any negative outside influence.
But name for me 2 or 3 groups of supporters that you're the most proud of.
Proud of?
Yes.
Oh, for sure. My support from my fellow judges. That I'm incredibly proud of. Absolutely. Trial judges around the state, and having the majority of them support me. They understand the importance of the work of the court and what we do every day, and those are the issues that rise to the state's highest court. I mean, we're the nuts and bolts of what happens at the Supreme Court level. We're on the front lines of dealing with the issues that rise to the state's highest court. Law enforcement support means a real lot to me, too. Every law enforcement agency that's endorsed has endorsed me, and I'm very proud of that. I'm really proud of the bipartisan support from Democrats and Republicans, district attorneys and sheriffs all around the state are supportive. There are a lot of great people out there who are counting on me to do the right things here and be their next justice.
Thank you. Linda Clifford, which of your groups of supporters are you most proud of, and which groups of Judge Ziegler's supporters should we be most watchful of?
Well, I too am proud of those endorsements that I've garnered since I began this campaign, starting with my honorary co-chairs, the statesmen of the state of Wisconsin, former Governor Patrick Lucey, a Democrat, and former Governor Lee Sherman Dreyfus, a Republican. I'm also proud to be endorsed by most of the congressional delegation of our state, including the most independent thinker in the state, Russ Feingold, as well as Senator Cole, and a number of legislators around the state. I am endorsed by business leaders. I'm endorsed by a whole slate of mayors, by a number of sheriffs and DAs and judges, especially courts of appeals judges. But I'm proudest, I think, of the endorsements I've received from the organizations that represent and work on behalf of ordinary people in the state of Wisconsin, because I think that they understand and appreciate how I grew up, and they understand as labor organizations and organizations that represent teachers and workers all around the state, what I went through to achieve what I've achieved, and that it's time to put a steel worker on the court. For example, growing up in the community that I grew up in a union family, blue-collar family, I understood something about solidarity, and the organizations that have endorsed me understand that those are values that don't leave me, will not leave me when I'm on the court. With respect to organizations that are endorsing Judge Ziegler, I'm most concerned about Wisconsin Manufacturers and Commerce and groups like Club for Growth, which have ties outside the state of Wisconsin and are determined to invest significant amounts of money in this race in order to control the outcome of the race. And I think this is a seat that should be sought and voted upon by Wisconsin voters and not by outside money, especially those that misconstrue records and that have been known to run fairly nasty campaigns.
I want to give you a chance, Linda Clifford, to respond to the the comments of Annette Ziegler of a couple of moments ago. You said you wanted to do that, but the question is whether or not there is a potential conflict of interest based on your husband's dealings as an attorney. I'd like to get your response to that.
Sure. It's a legitimate question by itself to ask how I will deal with any potential or speculative conflict that might arise in the future, should it arise at all. But it doesn't compare with Judge Ziegler's past and current conflict of interest, which is very direct and based not upon her husband's work, but upon the direct conflict of interest that's created by definition, by rule, by virtue of his seat on a board of directors of a party that she adjudicates regularly. She has not followed the rules. I will follow the rules. She has a conflict that's real. She creates as a smokescreen an attempt to create a conflict that is merely speculative, imaginary. My husband has had maybe 1 or 2 cases in the Supreme Court in his entire career, and probably the last one was 20 years ago. So the chances of a conflict arising are very slim, for starters. Cases take years to come before the court that might involve something that he's even tangentially interested in, so it's premature to suggest how I might act on any such case. And in fact, the executive director of the Judicial Commission, Jim Alexander, agrees with that it's too speculative. There's no point in trying to determine whether I have a conflict until the facts arise. To use it as a comparison is really a feeble attempt to deflect the situation that she's facing. Now, I've never suggested that she would have a conflict if issues arose that involve real estate development or construction law or the other things that her husband is involved in for a living, because I would expect that she would deal too with that conflict if and when it should ever arise, by reading the rules and complying with them, consulting with the Judicial Commission, and following the guidance documents that the Judicial Commission has created for just this kind of thing, including other justices who have spouses in professions that are sometimes a part of a Supreme Court case.
Why do you feel this is analogous?
Well, stated simply, if I'm sitting on the Supreme Court and I'm called upon to decide whether or not medical malpractice caps stand, this is an example, and that will likely be before our court. That's not a stretch to think that that'll be something the court revisits. If I decide they stand, that means my husband, if he wants to sue someone who walks in the door or is currently suing someone, is limited to that amount. If I decide they're overturned and my husband can get a larger verdict in front of a jury and know that will stand, that directly impacts my household income. That's but one example. It's a real example. This is not imaginary. And these aren't small claims bad check cases either. This is a real, significant conflict. If I, as a trial court judge, I recuse myself on 100 cases, and not all of them necessarily fit within a specific rule. You need to know if you can be fair and impartial in the case that you're deciding that's before you. If you know a party, or there's an attorney that you don't feel comfortable making a judgment call on, or if it's an issue that would be a problem, you recuse yourself, and that's what I do. And I oftentimes offer people, if they want, twice in the past couple of weeks, offered parties, if they want me to recuse, I would. That's a regular practice. However, for Attorney Clifford to say this is imaginary, I think is disingenuous, because it is real and it will directly impact their household income, and there's no way around that.
Let me continue on here, because I think we are going to continue on with the next question. Greg Borowski.
Yeah, I'm starting with Judge Ziegler, and then I have a related question to follow up with Linda Clifford. This gets right at the issue we're talking about with West Bend Bank, where you did not recuse yourself or disclose to defendants that your husband sits on the bank board. It's been made an issue by your opponent and outside groups. Earlier today, the Wisconsin Democracy Campaign asked the Court's Judicial Commission to investigate whether you violated the Code of Conduct. My question is this: do you believe that you complied completely with the Judicial Ethics Code, and do you believe you have a full understanding of the Ethics Code?
I think that as I said, I welcome, and I'm glad, frankly, I would like to have any objective review of this. The bulk of these cases are cases that never even came across my desk. They were decided by a clerk upstairs. This is small claims, high volume court, and they're stamped. That's something that is not addressed in the code in any respect. With respect to deciding cases of a default nature or deciding cases where both parties aren't present, again, it's not clear. There aren't necessarily clear rules. A clear rule that a judge does have also equally is to decide cases promptly, fairly, and efficiently. Now, let me also say this. I welcome that review. I'm happy to have that review, and I think there are ways to do things better, and I welcome that as well. You know, I'm constantly trying to change things around and do things better. We've revamped our criminal system. We revamped our civil system. Right now I'm working with the clerk and others to try to think through potential conflicts and how we could do this so we never end up in this situation again where anybody would be questioned, especially on a case where the ultimate result is the exact same. There's never going to be any showing of bias for or against any party in these lawsuits. They're largely, you know, just they are default judgment matters in small claims largely, and the fact of the matter is there's no possibility of financial gain. There is, Attorney Clifford is taking this and mushrooming this into an issue that is not a scandal. She can call it whatever she wants, but it's not. And we ought to call it what it is. She ought to address her issue and her conflict and work through that a bit more as well.
Yeah, to follow up, would you, having gone through this process now, would you do anything different in retrospect in these cases? And if you would...
Do I wish we weren't dealing with this issue? Sure, absolutely. And are there ways that could, any judge who's heard thousands and thousands of cases could look back and think of a different way or a better way of doing things? Absolutely. And I welcome that. You know, judges aren't perfect, but we do try real hard. And when you take a career of being a prosecutor and a judge and thousands of cases and have that review, and you end up with a couple that someone raises questions about. You know, there's nothing sinister here. There's nothing scandalous here. And no matter how Attorney Clifford wants to make it seem that way, there just isn't.
Yeah, just very briefly, if you would do it differently, shouldn't voters then interpret it that it was a problem the way it came down in the first place?
Well, therein lies the issue. I don't necessarily think there's always a problem when you can do things better, okay? And if there are better ways of doing them, you ought to strive to do that. Having said that, take a look at the Milwaukee Magazine article that outlined what turned out to be, this murky issue regarding stocks. Take a look at the article in the Madison paper dealing with judges sitting on cases. You could take, we live in a world as judges where we make difficult decisions all the time. People leave our courtroom oftentimes equally unhappy, sometimes one side a lot more unhappy than the other. And that's the nature of being a judge. You're always being second-guessed. We're subject to appellate review. We're subject to review at a lot of levels, not only from the people who appear in court, but we're subject to review from the First Level Court of Appeals, the Supreme Court, and on a variety of levels, through public scrutiny, through the election process. In the last election, during the primary, I had 85% of the vote in my county. These are people that know me the best, the people that know how I judge, how I rule, and how I've behaved and how I've acted for the last decade.
Okay, I'll give you a chance to respond a little bit in your answer, but I would also like you to address, following up a little bit on Mike's question and Judge Ziegler's comments, that these cases, you describe them as potentially tangentially related to your husband's line of work. If he stands to benefit his clients, then by extension him with his fees with a much larger damage cap, if something like this came before you, isn't that more than tangentially related?
Well, I'm not going to speculate on what that case might be, whatever it is that comes to the court, and whether my husband is even practicing law at the time. How can I promise that I'll recuse, or how can I even suggest that it's appropriate then to recuse if I don't know what the facts are now? I can say, however, I have read the Judicial Code of Conduct. I understand its terms, and I will comply with it in the context of the facts that might exist at that time. And that's something my opponent cannot say. What she has just described about improving her practices comes about 10 years too late. And I think your inference is very correctly drawn, that by failing to establish these procedures up front, this wasn't even on her radar screen. And it's not a question of whether she could stand to gain from the small claims court or default matters. The question is, the Supreme Court rule was adopted not only to give the judges an opportunity to decide, but to guarantee to parties that their case will be heard fairly and impartially. It requires the judge to exercise an obligation to recuse or allow the parties to decide if the case should proceed. The parties exercise the gut check, not the judge. And the fact that there's small claims and default cases, that just belittles the nature of litigation brought by poor and working families for whom $500 is a big deal. And some of these cases involved up to $45,000, which is a big deal. It might be small potatoes to somebody who's got a $3 million loan from the very bank that's involved in the litigation. But I think this demeans the notion of ethics by disregarding the obligation to take steps 10 years ago to make sure that these conflicts would not arise.
I mean, to follow up, I understand you don't want to speculate on a case that might come before you, but I'm a reporter and I can speculate. Let's just take
Lucky
this
you.
scenario. If a Supreme Court justice, not you, we don't know if you'll win, who will win this race, has a husband who's a lawyer who stands to benefit by an increase in caps, would that be considered a conflict in your mind for her to rule on that case?
I would have to examine my husband's practice at that time. I know that Justice Rogensack is married to a physician, and she hears medical legal issues all the time. Justice Bradley is married to a lawyer, and the same situation may occur in her practice. And I think that the Judicial Commission probably has counseled justices on this issue, and I will take that counsel, and I will abide by it.
Dan Blinka.
Let me take the spotlight off of the two of you for just a moment. What I'd like to do is to place this issue in somewhat broader relief. A number of media reports have alleged that conflict issues such as these are prevalent really around the state. In fact, one media source says that they are, quote, common, unquote. Now, I'm not asking either of you to address the merits of any of those allegations involving other judges. Rather, my concerns are more general. Linda Clifford, as a member of the Supreme Court, will you push for more vigorous investigations and enforcements by the Judicial Commission if you're elected?
Well, as an attorney, I spent 9 years on a committee that investigated attorney misconduct, and I'm familiar with the range of discipline. And also, I'm familiar because there were public members on our investigative committee very concerned about impropriety and the appearance of impropriety. As a justice, I would exercise the same vigilance on judicial ethics. I think the matter can be addressed both by education, so that we can take preemptive action to avoid rule violation, and, if necessary, continued investigation and discipline, because the cornerstone of our system really does rely upon the public's perception of ethical conduct by attorneys and judges.
Judge Ziegler, in light of this controversy, if you're elected to the Supreme Court, is this going to create, paradoxically, a conflict for you in sitting in judgment of either lawyer discipline cases or judicial discipline cases that involve conflicts of interest or other alleged similar behavior?
I don't think so, because I have a reputation for the last decade of being fair and impartial, reaching sound conclusions based on the facts and the law of each individual situation and each individual before me, and I would continue to do the same thing.
Thank you.
Among the cases that have drawn the most attention in recent years in the state of Wisconsin relate to liability issues, including what sorts of caps are appropriate. Indeed, I believe, in fact, I was reading today, Ms. Clifford, that you stated that the $350,000 cap on economic damages for medical malpractice, which has now been raised to $750,000, was an insufficient amount in this day and age. Was the result of these rulings on liability issues good for the state? Is $750,000 sufficient? Is it appropriate to even be making those comments, or is this really the purview of the legislature?
Well, I'm not going to comment on the adequacy or the constitutionality of the $750,000 cap, because that is likely to come back to the court. My comment on the $350,000 cap, though, I think was a reflection of the agreement by everybody that that amount was too low, because even the legislature had changed it. The cap that was ultimately rejected in the Ferdon case was something like $450,000, because $350,000 universally had been rejected. Now, if the case comes back at a different level, the court will be obliged to look at that cap and whether it has a rational basis and whether it was appropriately adopted by the legislature. But beyond that, I think it would be premature for me to express an opinion or predict how I might vote on that case.
Do you think it was appropriate to express an opinion on the $350,000 figure, considering the fact that you are running for state Supreme Court?
Well, it had already become the law of the land. It had already been rejected, not just by the court, but by the legislature. So I don't think it indicates or predicts how I might vote on a different cap, because that's a whole new ballgame with a different set of facts and perhaps a different development of the law between now and when that case is heard.
Were these rulings good for the state of Wisconsin?
I think it's probably too early to determine whether there will be any kind of reaction to the change in caps. I think that there are bodies and organizations that predict the end of the world as we know it, but I think that might be a bit hysterical, and I think we need to take a careful look at the actual evidentiary basis for claims that it's either good or bad for the state of Wisconsin before the hyperbole governs rather than the reality.
Annette Ziegler, will have you address this matter. Was the result of these rulings good for the state of Wisconsin? Do you agree with the $750,000 figure?
Well, unlike my opponent, I'm not going to give an opinion one way or the other, because I really do think that's going to be an issue that falls squarely in front of the Supreme Court in the very near future. I think what's fundamental here is to look at how someone would take a look at this issue. Now, Attorney Clifford feels that that is too low, and that's okay to have that feeling, but that's really not a judicial way of looking at things. You have to look at the rational basis test that's set forth in the law. You have to decide, is it patently arbitrary? Does it have a legitimate relationship to a government interest? Is this a statute that withstands constitutional scrutiny, considering and acknowledging the fact that statutes are presumed to be constitutional? Now, whether I like it or not is irrelevant, and that's what I'm saying. As a judge, I do all the time. You check your personal preference at the door, you put the black robe on, and you decide the case according to the facts and the law, not my personal preference on whether or not something else should be the number.
Starting with Judge Ziegler, in the last court session, there was about 80 cases that were decided by the court, and roughly half were decided unanimously. Each case, of course, helps shape the law, but so does the cases that the court does not choose to accept. My question relates to this. What areas of the law interest you the most as a potential jurist? That is, are there areas you consider most ripe for review or in need of legal clarification, whether in the criminal or civil side? I would note again, I'm not asking about a particular case. Thinking of it in NCAA basketball terms, I'm not asking you if you would prefer Marquette or Wisconsin in a matchup. I'm asking you if you would tune into that matchup. Good.
Well, my husband went to Wisconsin and I went to Marquette, so we're a pretty evenly divided household. But with respect to the cases that come before the court, about a third of them tend to be criminal cases in nature, of which I'm the only person who's had any experience whatsoever in criminal law, both as a prosecutor and as a judge. Another 40% or so are civil cases that come before the court, and they have fundamental and very important underpinnings to them. I enjoy the fact that I have been a lawyer in private practice. I did corporate and business litigation for several years at the trial and appellate court level on a lot of issues for mom and dad owned businesses and big, huge corporations. I worked as a prosecutor at the state and federal level. I've worked as a judge now, serving the public for the last 10 years in a general jurisdiction court, which again means we do everything: civil, criminal, family, juvenile, probate, adoptions, everything. You know, issues are important regardless of which area of the law that they come from, but it is good to have an understanding of all of the areas of law within which you intend to rule. I've had civil cases that have had fabulously interesting legal analysis. Several years ago, there was a helmet case that originated from my court, and it was an incredibly interesting issue to be decided. It actually bypassed the Court of Appeals. They decided to have the Supreme Court take it. The Supreme Court took it. They reached their conclusion. The legislature ended up taking action based upon the Supreme Court ruling. That's how our system's supposed to work, you know? And that was a very interesting issue. I've had other issues of a criminal nature. We've had a lot of 980 issues that generally surface at the Supreme Court level, sex offender or sex predator commitment issues. It's hard for me to pick just one because, frankly, there are a lot of interesting issues that I see, and it just is on the particular case that the court has before it.
Right. Well, I mean, to follow up a little bit, I mean, you've got this broad experience as you've described in your courtroom. If you can't pick one, pick two. Are there any areas where, or I mean, that interest you or you think need clarification, that the law, you know, is problematic, or what would strike you as an area for review?
I can address the areas that I think for sure we'll see in front of the Supreme Court. I think you're absolutely going to see clarification of the medical malpractice issue. We've talked about that all night. That's not going to be a surprise to anyone. I think we're going to see clarification of the lead paint decision and expansion of liability theories. Absolutely, those are going to be issues that. You know, creative lawyering, we've got a lot of good lawyers. They're going to come up with theories, and they're going to rise to the court to see whether or not that's expanded to a different industry. Criminal law issues, having had wholesale change in the last year and a half to 2 years, from identification procedures to show-ups to tape-recorded confessions to Miranda violations, and whether or not evidence can be suppressed. I mean, there are a lot of issues that are going to continue to resurface, let alone I've got a 980 case I've got to work on right now because of a new 980 issue. I mean, they're across the board, and they're all interesting.
Okay. Linda, Clifford, the same question. What areas of the law do you think are most ripe for clarification or review, or things that would strike you as needing a little additional clarification?
Yeah. I'm not unsympathetic to the question, to your question, which is challenging. It's kind of like asking which of your kids do you love the most, because I do enjoy all the practice areas I enjoy, which range from environmental law to constitutional law, First Amendment issues, open meetings, open records, access to government, anti-secrecy cases, some municipal law with many interesting land use and eminent domain questions, telecommunications deregulation, energy regulation. I think I enjoy those cases that involve conflicts between governing bodies and structural kinds of problems with respect to power sharing among the different branches. I think in the future we're likely to see, and I think I will be very interested in changes in public financing of education, for example, and the First Amendment issues that may relate to school choice and the voucher program, because I think those are very profound issues that affect our state from all kinds of different angles.
Dan Blinka.
I'd like to turn now to your judicial philosophies as members of the Wisconsin's highest appellate court. My precise question, however, requires, I think, a bit of background, if not for you, perhaps for our audience. You both know Judge Diane Sykes, a former member of the Wisconsin Supreme Court and now a federal judge in the Court of Appeals for the Seventh Circuit. In 2006, Judge Sykes delivered the annual Hallows Lecture here at Marquette Law School. Judge Sykes roundly criticized the Supreme Court's activist turn during the 2004-2005 term. Again, I know that you're both familiar with her lecture, but I just want to set forth several of her points. Her fundamental concern was the embrace by a bare majority of the Supreme Court of what is often called the new federalism. In particular, she criticized the court in three areas. First, its use of the state constitution to trump legislative determinations of public policy. Second, its disinclination, her word, to defer to either the elected state legislature's policy judgment or the United States Supreme Court's delineation of parallel federal constitutional doctrine. Third, the court's, quote, cavalier, almost dismissive attitude, unquote, towards stare decisis, that is the binding prior precedent, and traditional rules of construction regarding the Constitution and statutes. Now, I'm not asking, either of you to comment on those 5 decisions that she criticized. Rather, what I'm interested in is whether you agree or disagree with Judge Sykes' critique of the court's direction and how you would approach your role in light of her observations. Judge Ziegler?
Well, with respect to the court's role, I view the court's role as a more traditional one. I think that you have to be faithful to the role of being the third branch of government, a separate and equal branch of government, no more or less powerful than the others. And it's important not to invade the province of either of the other 2 branches of the government. I think the court's role is to interpret the statutes, constitutional provisions, administrative regulations according to their plain meaning. I think stare decisis is very important to follow. You have to be faithful to that. That's part of the judicial role. You need consistency, predictability, impartiality when deciding cases. Avoid overly broad holdings or sweeping results or remedies that really are outside of the court's jurisdiction to even invoke in the first instance. My opinion is that you have to faithfully adhere to the law, regardless of any political affiliation. And I think that that's something I've been trying to do as a judge, but it's not always easy to do that. Sometimes you're tempted to reach an outcome for someone you feel sorry for. Sometimes you want to create a remedy for someone in front of you that you just can't. But that's not the role of the court. The role of the court is one that's humble, it has humility, and it's modest. And the court needs to stay within that confined role to properly function and maintain its independence within the 3 branches of government.
Linda Clifford?
I have reviewed Judge Sykes' very thoughtful and scholarly comments. She delivered them orally, but I've read the transcript, and I take to heart what she advised with respect to the court's role. I don't agree with everything she said, but I do want to consider her point of view. I think my judicial philosophy can't and shouldn't be described in a one-word term, especially political terms, because they are quite misleading and can often lead to unexpected results, because judges shouldn't be bound by a political term in approaching the very difficult task of adjudicating cases. I think I'm most attracted to the discussion of judicial philosophy propounded by Justice Breyer, who describes a pragmatic approach. And this is especially appealing to me because what I offer is something so unique, 32 years of practical experience. So my philosophy would be informed by those 3 decades of hands-on work in the trenches, seeing the ramifications of decisions and how they affect lawyers and clients and public officials. Certainly I would start by being governed by the rule of law and putting aside personal preferences or political expectations and respecting stare decisis in precedent as a starting point for stability, but not in a blind way, because stare decisis needs to evolve, precedent needs to evolve, the common law needs to evolve in response to changes in technology, social values, legislative changes, and that's an appropriate role for the court. I was very much involved in making extraordinarily helpful and valuable changes in the common law of water use when I worked at the Department of Justice, changing a very archaic rule that had no place in Wisconsin in the 1970s. So I've seen how that is needed. Beyond that, I would interpret and apply statutory enactments to fulfill and promote the purpose for which they were enacted, to discern the legislature's intent and follow it and enforce statutes to promote that intent, unless it violates civil liberties or fundamental rights or other statutes or constitutional provisions. I don't consider that activism, and I don't consider that legislating from the bench. That's judging. And that's what I'm trying to do as the next Supreme Court Justice.
Thank you.
Unfortunately, that'll have to be the final question. We've come to the time of the evening for closing statements, 1 minute each, again based on the coin toss outside this room earlier in the evening. Annette Ziegler will go first.
Well, thank you again for the opportunity to be here tonight. You know, when I was a kid, I grew up in a family-owned business in Grand Rapids, Michigan. My parents had a hardware store there, and my brother runs it now 56 years later. And the job that I always wanted to do was to run the cash register. But my parents had different things in mind. They wanted me to price the merchandise, clean up the acetone, wait on customers, get the trash ready, take the goods off the conveyor belt. I had to work my way up to running the cash register. And you know what? I was better off for it. Because when I did have to run the cash register, I could answer people's questions about the other places they needed to go and what they needed in the store and how you could find the price for something. You know, that's how I was brought up. You work your way up to things. I'm the only person running for this seat who has been a judge. That's where these issues begin that end up at the state's highest court. I am the only person running for this seat that has been a criminal prosecutor and has sentenced people. I'm the only person running for this seat who has experience in every area of the law, and I respectfully ask for your support and your vote April 3rd.
Linda Clifford?
Thank you again for attending and for your attendance tonight. As a Supreme Court Justice, I would continue working as I did as an attorney to ensure the integrity of our justice system and the ethical behavior of our attorneys and justices. In addition, I am the most qualified candidate because I bring 32 years of quality experience representing real people with real problems, a voice the Supreme Court doesn't have right now, but sure needs more than the voice of another trial judge. I'm the only candidate with experience that's actually apropos of the job of a Supreme Court Justice, appeals. I'm the only one who's argued a case there. I know what the Supreme Court does. It's not what a trial judge does. The body of experience I would bring has been recognized with honors from the Super Lawyer Program, from Leaders in the Law, from the State Bar of Wisconsin, from Best Lawyers in America. I will bring integrity, honesty, high ethical standards, legal scholarship, and experience that you deserve on your Supreme Court. And between now and April 3rd, please compare our records and decide who do you trust on your Supreme Court. I'd be honored by your vote on April 3rd. Thank you.
Thank you, Linda Clifford. Thank you, Annette Ziegler. Let's give a round of applause to the candidates. Before we go, just a couple of more thank yous. We do want to say, as representatives of Marquette Law School, that we're honored to hold this debate here tonight. We also want to thank our co-sponsors, the Milwaukee Journal Sentinel and Time Warner Cable. Again, a reminder, you can see a rebroadcast of this debate on Wisconsin On Demand. That's Time Warner's Channel 1111. Thank you very much.